This morning. I'm Senator Julie Kushner and co-chairing this committee and anxious to move the agenda today on important bills that we've heard in public hearing. So I will not belabor the point. And you got that, huh? And ask my co-chair if he has any comments.
I do not. Okay.
And Senator Sampson?
Nope.
Representative Ackert?
Ready to get to work, Madam Chair.
Great, thank you. So then we'll move to item number one. We'll move to item number 3 on the bills for review. And it's my understanding that we're going to go one by one. And so we will begin with Senate Bill number 910, an act concerning permanent partial disability benefits and pension offsets. Is there a motion?
So moved. Rep. Hughes.
Moved by Representative Hughes and seconded by Representative Sanchez. I think people are familiar with this since we've had public testimony on it. So if there's any questions or comments, I would entertain them now. Senator Sampson.
Thank you very much, Madam Chairman. I know we've had this bill before, but even though I understand the policy language and how that would be changing, I don't know that I've ever really understood what the goal was behind this. Can you just share with the committee, what issue we're trying to address and what the goal is behind this language, Madam Chairman?
Thank you. Certainly. The issue is that when a person in public service has a permanent partial disability that they lost, say, for instance, use of an arm or have a lost use of a hand, that if they are working and going back to work, they would receive the full payment of workers' compensation. If they go out on a pension, then they can have that payment that would have come to them had they been working. That payment is taken out of their pension. And so this would not allow a person to have their permanent partial disability award reduced from their pension. Senator Sampson.
Thank you very much, Madam Chairman. Okay, I mean, that makes sense on its face, except that, and I'm certainly sympathetic to anyone that is, suffering some sort of permanent or partial disability, and we want to make sure they're made whole. But my concern, I guess, is that I think the bill makes them potentially more than whole. And I'm just wondering if it's the role of this committee to make that determination. Is it accurate to say that this type of thing has been negotiated between the employer and employee in the past, Madam Chairman?
Thank you, Senator Sampson. Yes, it has been negotiated in the past. As to the question of whether it makes them more than whole, that certainly does occur when a person is continuing to work. They could potentially be made more than whole because they have suffered the permanent loss of some part of their body. So I think that we believe that this is fair. If you in this service to our state and our cities and our municipalities lose function of a part of your body permanently, then there is a belief that you should get some monetary compensation for that. And it really doesn't have anything to do with your salary, or in this case with your pension, or it shouldn't have anything to do with that. Thank you.
Well, I appreciate that answer. And certainly I think, people listening might agree that someone deserves compensation if they suffer a disability, that sort of thing. The question I guess I have is that, is it up to us to decide that by making a policy that we're not involved in? Because my understanding of this bill proposal is that this is a negotiation between an employer and a municipality, an employee in a municipality, and they're both capable of determining what benefits are appropriate and, what they might agree to in their negotiated work contract. And here we are, we're interjecting ourselves in something that has nothing to do with us, really, because that's their separate negotiation. And we're saying we're going to take the side of the employee and require that there can be no negotiation that offsets this amount. And I guess that's my objection to it on its face, really, is that I don't think this is something that we should be involved in. This is something that has historically been collectively bargained, and I think it should stay that way. Is there a reason why the collective bargaining process is not adequate in this particular situation, Madam Chairman?
Thank you, Senator Sampson. Certainly, there are many things within our policies and our laws of our state that could be collectively bargained and often are collectively bargained. But it really is our responsibility as the legislature to put forward what we think is good policy. And I think there's been sound testimony that suggests this is good policy that the state should adopt, regardless of whether or not a unionized workforce determines that they want to collectively bargain for this, or whether a group of public employees that are not unionized determine they don't have access to that avenue.
Thank you, Madam Chairman. I'm not sure I understand. I mean, it's easy to say something is good policy, but you're implying that this is better policy than the current law, and the current law is collective bargaining. So is it better for the state to arbitrarily take one side of a private contract and negotiation between employers and employees than to let those parties work that out? Through you, Madam Chairman.
I believe I already answered that. Thank you.
Okay. I just find it odd. I know that you're an advocate for collective bargaining, and here we are, we're saying that collective bargaining is not working in this particular situation and that we've got to step in. And I will just say for the record that, you know, I've seen more and more of this in recent years, which is that this body is using the force of the state government to take sides in contracts. And it happens all the time in lots of industries. I used to serve on the insurance committee, and that was commonplace there. But now we're engaging in taking sides by writing state laws that favor one side of a business agreement. I think that's highly dangerous. You know, there was at least an implication in our founding documents and our U.S. Constitution that private contracts are something that the government should not interfere with. It's a basic core concept of America, that people are free to make their own decisions, to have liberty, as our declaration says, and pursue their happiness, which means to engage in whatever fruitful activity they want. When we're suggesting that either one party is not capable of sticking up for themselves, that's one issue. And when we say that we should take the side of one party or another, I think that's also dangerous. So I'm opposed to it on those grounds, Madam Chairman, simply because it's an interference with a private agreement. And I also think it is using the legislative body as a tool to assist people that are collective bargaining, you know, by bargaining on their behalf and using the force of government for that. I think that's a dangerous precedent. But I have a further issue, which is that it seems to me that if this policy goes into effect, ultimately it will have no other impact than to raise property taxes, because most of these disputes are between municipal employers and their employees. And in the past, those municipalities have been able to negotiate a reduction or an offset in those payments to the benefit of the taxpayers of the community. And you're eliminating that here. So is that correct, that ultimately this will has no other possible impact but to raise property taxes?
Thank you, Senator Sampson. Two things. In terms of the cost, it has always been my belief as a taxpayer and a resident of Connecticut that I have responsibility to make sure the people that we hire to take care of us, whether it's a firefighter, a police personnel, somebody who drives a bus in our town, we have an obligation to make sure that we're taking care of them properly, so that if they suffer a permanent partial loss of a body part, a hand, an arm, a back injury that disables them for the rest of their life, that's part of our obligation as citizens, as residents of the state, to make sure that we're taking care of the people who serve us. I just want to make one correction in your comments. I rarely do this, but I think you paraphrased me incorrectly when you said that I was saying that collective bargaining isn't working. I've never said collective bargaining doesn't work. What I said is that I believe we have an obligation to set public policy, even where there is an opportunity to collectively bargain around those issues. So I just want to be clear. And I know you didn't want to suggest that I didn't believe in that collective bargaining works. You might have tried to slip that in there, but you know I don't believe that. Thank you.
Well, thank you, Madam Chairman. I on an honest mistake if I misspoke, because I'm surprised is really all that it boils down to. Is I'm surprised that you would put forward a bill to replace collective bargaining, because effectively that's what happens here. This is a process that is collectively bargained currently, and if we pass this law, that will no longer happen in this case. And I guess we just have an ideological disagreement about the role of the state government. You said that we have an obligation to take care of people, and I don't think that that's the role of the state government at all. The state government's here to provide for the public safety and to protect the rights of our constituents so that they can engage in fruitful lives and have prosperity. I don't see the government as the answer to problems. The government simply finds a way to prevent willful business partners from engaging, freely. And this is another example of that. This is going to take away an opportunity that would otherwise exist, because a municipality being able to negotiate this offset might be able to hire an additional employee that they no longer will be able to if this happens. And ultimately, the costs will rise, and it will impact every one of our municipalities. And Connecticut, of course, already has some of the highest property taxes in the whole country. And it's driving away businesses. It's driving away retirees. And I just think this is another case where state government is misguided. It is supposedly trying to help some small segment of the population, but will ultimately negatively impact far more people. And I'm going to oppose it based on those grounds, Madam Chairman. Thank you.
Thank you. Representative Acker.
Thank you, Madam Chair. And I look at this in a similar way in terms of a budgetary process. Listen, we understand that the good workers that we have in our communities deserve their full retirement. And when they get to that level of, getting that level of retirement, but it's hard to budget in this case here, a cost that's unknown, that you have a person that may or more than one. I have small communities, so I know we've had people that, especially in a public works area, that have been injured, been out on disability, collect some disabilities, but they also, at the point where they got to their retirement, retain their full retirement. And that's what the number that they understood that they were going to get. When you get to that level that they understand, and that's what the town knew what they were going to get and what their obligations were. If unfortunately we have a situation where somebody is hurt and has, or more than one, that has to, be considered to be, paid an additional amount of money that not budgeted for, and the concerns are obviously costs of our property tax in our community. So at the point that it's an unknown number, and it's hard for a community to actually budget this and consider it at this time. If it is, obviously, if they collectively bargain this into their obligations, and they understand that, if I add in an extra 10% per employee, that this may happen, and they understand that that's going to be the cost, and that the taxpayers of our community understand that that's part of their obligation, as you mentioned, to in a manner to support those individuals. So on those issues, I'm going to oppose this legislation. Thank you, Madam Chair.
Thank you, Representative Hughes.
Thank you, Madam Chair. I just wanted to make a comment about the contract. Almost nobody enters into municipal or state employment planning to become disabled or injured. Almost no one. So that may not be a large part of a contract of really scrutinizing, and an equal part of the contract that an employee takes on. What they do scrutinize is their pension, that they can expect after retiring after X number of years. So that is a pension that is earned by our teachers, by our employees, and that is separate from the getting injured on the job. And that's why this, that there is an equal part of contract. I take a little bit of measure with because I don't think it is. I think that people do not plan on getting injured and then don't expect that be paid. They're already bearing the cost of being injured and disabled, and they don't expect to have that cost to the municipality or to the employer come out of their earned pension. And I just wanted to make that clear. Thank you.
Thank you, Representative. Senator Sampson.
Thank you, Madam Chair, for the indulgence. I just want to make it clear, just for anyone listening, that the current law does not interfere with anyone's ability to earn their full pension. It just simply says that if negotiated by the parties, the employee and that municipality, the municipality may reduce the amount of their pension by their disability payments. So I don't disagree that this may be something that no one is going to pay a whole lot of, or a few people would pay a lot of attention to at the time, but it's also not going to diminish their overall retirement. And like I said, in a perfect world, I think it's great. I think everyone should get, extraordinary benefits and extra money and so forth. I just question whether it is our role to engage in that or whether or not it's really up to the parties that are involved to make those choices. Anytime we're going to step into any contract between anyone, we're necessarily choosing sides. And I believe that is not how our country is supposed to work. Our country is supposed to work based on equal protection under the law. I know a lot of my colleagues, particularly on the other side of the aisle, are concerned every time someone is marginalized based on the group that they're attached to, whether it be by race or gender or location or whatever it is. And I don't disagree. We should treat everyone equally, and that includes parties to a contract, and we should not be picking sides, no matter which side that is. Thank you, Madam Chairman.
Thank you. Any other comments or questions? If not, I will ask the clerk to call the roll. Oh, I'm sorry.
Thank you, Madam Chair.
I apologize. I have to
Weir here.
remember to look at the screen too, and I have it right in front of me. Representative Weir.
Thank you, Madam Chair. I was a former police officer, worked in a public setting, worked along, had coworkers who were injured. And I recognize that they have, during that process, earned every right to their pension, earned every right to whatever settlement was made by and between them, the municipality, the insurance company that's involved. In this role today, I hear from seniors and residents almost daily about the cost of living, about the taxes, about them living on seniors in particular, living on fixed incomes. And I have a grave concern with the state interjecting itself in really over the will of 169 separate municipalities who have they currently have the option to negotiate these benefits or these settlements. I shouldn't call them benefits when somebody's injured, but they certainly have the ability, town by town, to negotiate. And I think we are overstepping here, causing a unfunded mandate. I believe we've heard this from my colleagues, but I just want to be clear that my constituents are pleading to control to be looking out for their costs. They want to be able to stay here, retire here, afford to live here. And by the state, by us, this legislative body getting involved, pushing forth this legislation, we really are overruling the will of and the ability of the towns to collectively bargain these settlements on their own, town by town. I believe that it should be left to the towns, and for that, I have to oppose this. Thank you, Madam Chair.
Thank you, Representative Weir. Are there any other comments or questions? Seeing none, I'll ask the clerk to call the roll.
A roll call vote has been requested on agenda item 1, Senate Bill 910, an act concerning permanent partial disability benefits and pension offsets. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera,
Senator Cabrera votes yes.
Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Ackert votes no.
Representative Hall,
Representative Hall votes yes.
Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino. Thank you, Madam Chair.
Thank you. We will be holding votes open until a designated time that we'll arrive at the end of the meeting. Moving to the next item on the agenda, number 2, Senate Bill number 911. Is there a motion?
Rep. Hughes, oh, sorry.
Before you make that motion, I just like to offer another motion that is that this bill rightfully belongs in the Judiciary Committee. It has to do with penalties for committing crimes. And I don't believe that is under the prudence of this particular committee. So I'd like to move that this bill has a change of reference to the Judiciary Committee.
It's been moved and seconded that this item be referred to the Judiciary Committee. I'm going to pause the meeting, recess for a moment. We're going to take a brief recess and hang in there.
without joining a
Oh,
meeting.
good, I'm here. Just Jen.
Okay.
I'll call you back. Thanks, bye. Bye.
Representative Yakarino?
I just got on, I'm sorry, I was at the doctor's this morning.
You're just not on mute. I just wanted to make sure you knew.
Oh, it's me, thank you.
No problem.
I miss being there.
Okay, we are ready to go back on the record. So there's been a motion and a second to refer this to judiciary. Is there any discussion? Hearing none, then I would ask, I assume you want a roll call vote? I would ask the clerk to call the roll.
A motion has been made and seconded to refer item 2 on the agenda, Senate Bill 911, an act increasing the threshold amount for felony unemployment compensation fraud, to the Committee on Judiciary. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes. No.
Excuse me, Mr. Clerk, I'm in the habit of voting yes in this committee, but that was a different vote, so I would like to change my vote. Senator Kushner votes no.
understood, Madam Chair. Representative Sanchez,
Representative Sanchez votes no.
Representative Wilson,
Representative Wilson votes no.
Senator Cabrera,
Senator Cabrera votes no.
Senator Sampson,
Senator Sampson votes yes.
Representative Ackert,
Representative Acker votes yes.
Representative Hall,
Representative Hall votes votes no.
Representative Hughes,
Representative Hughes votes no.
Senator Lesser, Representative Weir,
Representative Weir, no. I'm sorry, yes.
and Representative Yakarino.
Representative Yakarino votes yes. Thank you.
Thank you.
Thank you. That was a little funny. Would the clerk please call the tally?
Tally is as follows. Vote 4 votes yay, 6 votes nay. The motion fails.
Thank you. Moving on to item number 2, is there a motion for Senate Bill number 911?
Rep Hughes, so moved.
Second.
There's been a motion, it's been seconded. Is there any discussion? Senator Sampson.
Thank you, Madam Chairman. See, you could have spared yourself conversation simply by moving this to another committee. The bill before us changes the penalty for certain types of criminal acts. It would change the fine, or rather the financial threshold of a compensation fraud crime from $500 to $2,000 to change it from whether it would be a misdemeanor or a felony. I hope that was clear. At any rate, I think number one, that this bill is moving in the wrong direction by reducing the penalties for criminal acts. But the larger issue really is that this bill should be discussed in the Judiciary Committee. It doesn't belong before us. I stand by that. And even if it does pass out of this committee, ultimately it is going to go to the Judiciary Committee, and it'll be debated there as well. But I just wanted to have that on the record. Thank you, Madam Chairman.
Thank you, Senator Sampson. Representative Ackert.
And thank you, Madam Chair. You know, this is a piece of legislation that, you know, if I knew more about, you know, felonies and penalties and things like that, I'm not in the Judiciary Committee and hope never to be in that committee. But sometimes it happens. And it's just one of these things where I could see the laudable point to this is that, you know, somebody, I granted, something happened wrong and maybe inadvertently, but they knowingly did something wrong. Maybe they got an extra payment. They go, whatever, the state's giving me some extra money out of the account. So I can in a way have some, some understanding of that. It's so I'm at pause with this legislation, to be quite honest with you. And I understand we're saying, well, we're allowing somebody to have a higher threshold for a different penalty. But through you, Madam Chair, are they still liable to repay the money regardless, in this case here, if we raise the threshold? Through you.
Yes, Representative Acker, they are liable for all of the penalties associated with a violation like this, including paying back the money with penalties, and the penalty of not being able to receive unemployment for a period of time. So there are a lot of conditions that they still will have to meet. The only difference is whether or not it's considered a misdemeanor or a felony.
And thank you. And then if I guess, so if they, is there any point, does it escalate if they refuse? In other words, like, okay, it's a misdemeanor. You're already charged with a misdemeanor. You still have to repay that. If they don't take that action and they completely say they're not paying this back, whatever it may be, does it escalate from there? Through you, Madam Chair.
This does not reduce any escalation that already exists under the law. So I'm sure there are escalating factors when somebody refuses to pay back unemployment that is owed, but this bill would not, this proposed legislation would not change any of that. They would still receive the same penalties that would exist should they refuse to pay unemployment back.
Thank you, Madam Chair.
Any other questions or comments? Seeing none, then
Madam Chair,
I'm sorry, I
Maybe-
keep doing that and I have to train myself to look at the screen.
it's okay, I'll speak up.
Go ahead, Representative Weir.
Yeah, I have a couple of questions. Are we, in other, I'm no expert in felonies versus misdemeanors on all accounts, but are we saying in this case of where somebody commits fraud, that the threshold for committing fraud, which ultimately this is theft by way of fraud, is there a high, let's just say in the instance of somebody robbing a convenience store of $500, is that a class D felony as well? So in other words, here somebody received $500 that they are not entitled to by way of fraud, knowingly or unknowingly. And yet in the other instance, somebody steals $500 by way of force. Is that considered a class? Will that remain a class D felony, or are you? I'm not sure at what if all these crimes will fall under. We'll have separate thresholds for stealing basically the same amount of money. Hope that makes sense.
That did make sense. Appreciate your question. We did receive testimony in that that answered that question, and the testimony was that if you were to steal private property, the threshold for a felony would be $2,000, and I believe that's why this bill is before us, is because we are out of sync with other penalties and for other kinds of theft. Any other questions?
Thank you, Madam Chair.
Seeing none, then I'd ask the clerk to call the roll.
A roll call vote has been requested on item 2 on the agenda. Senate Bill 911, an act increasing the threshold amount for felony unemployment compensation fraud. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Rep. Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Sampson votes no.
Representative Ackert,
Representative Acker votes no.
Representative Hall,
Representative Hall votes yes.
Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
I'm sorry, Representative Weir, I didn't see you on camera when you said that. Would you mind?
Representative Weir, no.
Thank you. Representative Yakarino,
Representative Yakarino votes no.
thank you.
Thank you. We will be holding votes open today. Item number 3 on the agenda is Senate Bill number 912. Is there a motion?
Rep Hughes, so moved.
Representative Yakarina, if you wouldn't mind muting yourself. Thank you.
Sorry.
It was moved by Representative Hughes and seconded by Representative Sanchez. Is there any discussion or questions? Seeing none. Oh, Senator Sampson.
Sorry, Madam Chairman, I was slow on the draw trying to find the right documents in front of me. Just this proposed bill would effectively make the probate court system in the state a unionized state agency. And I'm just curious what made that come about. Did the probate court employees begin a process to collectively bargain or to organize? Exactly how did this come about?
Thank you, Senator Sampson. There was testimony from probate court employees. We have heard this bill in the past and have heard directly from probate court employees that they would like the opportunity to choose whether or not to unionize. Senator Sampson.
I'm just having a little trouble with the section 2 subsection B, which is line 17 through 23. And it says probate court employees shall be deemed state employees for the purpose of Chapter 68 and shall have the right to bargain collectively. And that just reminds me of something that happened several years ago with the daycare providers and the folks that are employed based on Medicaid waivers. Effectively, those are folks that are receiving a check that is not for them, it is for someone else, but they're providing a service for that person that is receiving the benefit. This is a little bit different, but the notion that we have to actually put language in a bill to say that they're state employees for a specific purpose, are they not state employees for another purpose, Madam Chairman?
I think this is clear that they are, that this would make them state employees, as you've suggested, for the purposes of collective bargaining. And this bill is limited to that in terms of any other impact on their employment, whether they are state employees or not state employees is not impacted by this. It's only for the purposes of collective bargaining.
I appreciate that. It just seems odd to me that we would say that we're going to make these folks state employees and only for that one purpose. Are they not entitled to the other benefits that state employees receive, pension, healthcare, et cetera?
I believe there was testimony that they do receive those benefits.
I appreciate that, Madam Chairman, and that makes me wonder about why they would go through the trouble to organize. Let me just follow that up by asking, are there any other cases in our state where we say to a set of independent contractors who work with the state or people that provide services that receive a benefit that you're aware of, where we effectively call them state employees only for the purpose of collective bargaining and not for any other purpose?
If I understand your question correctly, I think you just answered that previously by pointing out the child care providers that are state funded do receive that same, they are considered employees for the purposes of collective bargaining, but not considered state employees.
No, and I'm obviously aware that I mentioned that. I was just curious if you knew of any other areas besides the ones that I mentioned. But it's neither here nor there. Let me just ask you this question. Under current regime, and I feel a little bit at a loss because I don't really know how the probate court operates 100%. But my impression is that probate court judges are elected by the people, and effectively they have the power to choose their staffers. Would they be losing that ability to choose the people that they hire and fire to work with them on their staff if this collective bargaining goes into effect? Through you, Madam Chairman.
Thank you for that question. Just like any other group of employees that chooses to unionize, they could definitely bargain over the conditions for firing, for instance. That's very common in union contracts. Generally speaking, employers have the right to hire in union contracts. So, it would depend entirely on what was negotiated in terms of what other conditions had to be met by the judges in considering an employee or in considering letting an employee go or disciplining an employee.
I guess, and one final question, and this is more of a technical thing than anything, which is that I don't really understand why we need this legislation. It would seem to me that any group of employees can organize and begin the process of unionizing and collectively bargaining, unless they're strictly prohibited under some other federal or state law. Is that the case here? It seems to me we are turning them into state employees for the purpose of collectively bargaining. Could they collectively bargain if they were not deemed state employees as the bill requires? Thank you, Madam Chairman.
I don't believe there would be an obligation on the part of the courts to collectively bargain with a group who chose to collectively bargain, because there would be no obligation in a current state law. Any other comments or questions? Okay, seeing none, then I will ask the clerk to take the roll.
Madam Chair,
I'm sorry, Representative Yacarino, and I even got reminded this time by Representative Sanchez. So
Thank you.
I'm-
I apologize, getting on a little late, like I said, but would the chief clerk administrator be also part of this in the court system?
Are you asking if they would be considered an employee? for
Would we
purposes-
consider excluding them from this?
I'm sorry, could you rephrase the question?
Would it be possible to exclude chief court administrators from this?
I'm not as familiar with the roles and responsibility of the chief court administrator, but I would assume that they would be considered not eligible for collective bargaining based on their supervisory.
I think that should be in
managerial
writing, because if we're going to pass, if you're going to pass something like this, that could be problematic. So I think you really need to look at this. I think could be problematic.
Thank you. Any other questions or comments? Steve, Representative Weir, I apologize.
right, all right. Thank you. I finally figured out how to use the raise hand button. I guess I would like to point out that I've heard from my local probate judge who has concerns with this. And we are scheduled to meet, but I recognize in the fact that, we elect our probate judges locally, and they hire their staffs locally, or their staff people locally. The staff people, are compensated locally, and our benefits come locally. I have a grave concern with taking this mandate to the state level. I see no reason why, if a group of people choose to organize, just as they do in other parts of our municipality, we have public works, we have police, public safety people who organize locally. I see no reason why a group of court clerks, probate court clerks and employees could not do so willingly on their own, of their own volition, versus action from this body. So I do have a concern with that, and certainly more information to come from my local probate judge. But I want to raise that concern, and I'll be voting no because of that. We're superseding local control and will. Thank you, Madam Chair.
Thank you. Seeing no other hands, then I will ask the clerk to call the roll.
A motion has been made and seconded on agenda item 3, Senate Bill 912, an act concerning the status of probate court system employees. The action is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Ackert votes no.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino.
Representative Yakarino votes no.
Thank you.
Thank you. We will be holding votes open. Next, we will move on to item number 4, Senate Bill 938. Is there a motion?
So moved. Rep. Hughes.
Second.
It's been moved and seconded. Is there any discussion? Senator Sampson.
Thank you, Madam Chairman. I won't rehash this this bill here today. We debated this in the committee last year and also on the Senate floor at significant length. And I think the title is self-explanatory about what the bill does. It says an act concerning unemployment benefits for striking workers. To me, it's an absurd notion on its face. People are voluntarily walking off the job, and I don't know that that is a justification for providing them with benefits, especially when those benefits are ultimately paid for by employers. And it's another case where we are taking the side of one party in a labor dispute as a state government. I can't think of anything more in direct contradiction to the way our American system was laid out. I'll be voting no. Thank you.
Thank you, Senator Sampson. Any other comments or questions? Seeing none, then I will ask the clerk to call the roll.
A motion has been made and seconded on agenda item number 4, Senate Bill 938, an act concerning unemployment benefits for striking workers. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Ackert votes no.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino,
Hold on. Representative Yakarino votes no. Thank you.
thank you.
Thank you. We will be holding votes open. Moving on to item number 5, House Bill number 6550. Is there a motion?
Rep. Hughes, so moved.
It's been moved and seconded. Is there any discussion? Representative Ackert.
Thank you, Madam Chair. And to start with, I've heard a couple, we've contacted by a couple groups, whether it's insurance organizations regarding workers' compensation and the process. So I've got very conflicting comments by two sides, and I appreciate both of it because that's how I want to have people weigh in. So, any chance could you walk me through this process of how somebody, when they're, because I'm getting it from both sides saying one thing and the other. How do you see this legislation? If you don't mind, a little deliberation on this from your point of view and raising this legislation, Madam Chair.
Thank you. Well, what I heard testified to, and I did go back and read the testimony last night, is that at this moment, an insurance company or an employer can choose to discontinue paying for a medication that has previously been paid for under workers' compensation. And the reasons that were given by the insurance companies where this might occur is that they determined that a medication isn't suitable or the right medication, or could even be dangerous. And what I read last night from a medical doctor is that they believe that that decision should be made by the doctor, not by a third party insurer or employer. And I think this bill then prevents that employer or insurer to immediately cease paying and would require them to be able to get approval from the workers' compensation administrative judge, I believe it is called now. We changed that title a few years ago, administrative law judge, and they would have the obligation to go through that process to discontinue paying for that medication.
Thank you. And I listen, not knowing this, issue very well, and they talked about a form being filled out. So they said it's just this simple form. But I think this simple form creates a process, is my understanding, that then would create a hearing. And I've heard that, well, no, that doesn't have to automatically be a hearing, but if there's any conflict, if the form's filled out and it said, here's why you're not receiving these benefits, that at any point, the employer and or the insurer can, say, no, that's not how it works. We're not, you've got this form, and whether it's the doctor or something opposes that, it actually becomes a process that requires a hearing. And I haven't read anything that eliminates that process that would bog this down. Do you, through your discussions, do you see that not being accurate?
I did note in the legislation that in order to appeal this, they first have to be served notice that it's going to happen, that there's going to be a discontinuance, and then they have the obligation, the individual has the obligation of within 15 days requesting that be heard. And so it could be that if there was a situation where the employee did not file that there would be no hearing. I do think that what I like about this piece of legislation is it really prevents a situation where somebody doesn't know until they get to the pharmacy that their medication has been discontinued. And I think it's a fair process. And I think it's a fair question to say that really there needs to be an opportunity for the physician, for the prescribing physician, to weigh in, that this isn't a decision that should be made by insurance companies or employers. So I think it's a very legitimate process. I did note in the legislation that there's an expedited process, that it does bump these hearings up so that there isn't a lengthy delay from the time in which that request has been made.
And thank you, Madam Chair. And I thank you for bringing that up. When you jump the line on something, in case of a process, there's somebody being bumped, or a process, another hearing being bumped. So that has a little bit of a concern of mine. I understand that someone probably needs this prescription for, very viable reasons. It's just, when you get two sides talking to you, and you want to get to what the actual fact is and what actually the process is. And I get it. I wouldn't want to be the individual that walks up to the pharmacy and says, your drug isn't there. But if you've been notified, hey, by the way, this is not going to be, here's the letter, and that was the case. Okay, I'm not getting this. But it seems to me that the after process is a little cumbersome, and that's what I'm having pause with. I'll listen to some other dialogue and some other questions. I may have a backup question as we go through this, but thank you, Madam Chair.
Certainly. Any other comments or questions for Senator Sampson?
Thank you very much, Madam Chairman. On the surface, this bill, I don't necessarily object to its intent. It seems like a consumer protection, or protection for employees, and I don't object to that. I'm just very confused reading the language, because some of it doesn't seem like it fits together. Maybe I'm reading it wrong, but if you read lines 18 through 25, this is the part that says that if an employer or an insurer acting on behalf of the employer wants to discontinue or reduce the payment for certain drugs, they have to provide the notice. And then the next few sections are all about the notice itself and what has to be sent. What confuses me, I guess, is that in lines 44 through 47, it says if you object, and I'm presuming this is the employee being notified, if you object to the discontinuance of prescription payments as stated, you must request a hearing. And it goes through that process. But what I don't understand is the next few sections, starting line 53 through 72, where effectively it says that the discontinuance and or reduction shall not occur without the workers' compensation judge saying so in writing. Now, does that happen at the beginning of this process or only after the hearing? And I guess that's what I'm confused with. And my question's almost answered in section B, line 59. It says the work comp judge or administrative law judge, as we now call them, shall not approve any such discontinuance prior to the expiration of the period of requesting a hearing or the completion of such a hearing. So they're saying that if you can't stop or if you can't approve a discontinuance until after a hearing, this seems to me that in every case there has to be a hearing. And that's what I'm finding a conflict with what I'm being told versus what the bill says. Because it's quite clear, no proposed, on line 53, no proposed discontinuance or reduction shall become effective unless specifically approved in writing by the administrative law judge, period. And then it says that that judge can't operate until after the completion of a hearing.
Thank you for that question. I think the language is very specific. The administrative law judge cannot approve the discontinuance prior to the expiration of the period for requesting a hearing. So they could, in fact, after 15 days, if there's no request for a hearing, they could approve it without a hearing.
Well, I appreciate that, but how does the administrative law judge even know about the discontinuance? If that is something that is happening between the employer and the insurance company and the employee directly, and they do not request a hearing, then how does the administrative law judge ever know this is even happening? Through you, Madam Chairman.
Thank you, Senator Sampson. If you look back to lines 22 through 25, it says such employer, insurer, other entity shall notify the administrative law judge. So the administrative law judge gets notice at the same time as the employee by certified mail.
Thank you, Madam Chairman. I appreciate that. Was there any testimony by the Workers' Comp Commission or anyone there about how they feel about having this new responsibility of making decisions on these? And I don't know, certainly I've never been put in that role myself, but I mean, I think we should all ask ourselves, if I'm an administrative law judge and I'm getting this notice, don't I have to have a hearing in every case? How am I going to just start approving these willy-nilly? I don't think that they're necessarily going to be informed well enough to make, competent decisions unless they have the facts of each case. I guess, the issue that we've had with this bill really is the notion that this is going to end up taking up a lot of the time of the Workers' Compensation Commission, which is one of the amazing state agencies that I think is actually relatively efficient. But we're putting this particular situation almost to the head of the line, that these have to be taken care of, very quickly. And that might move other business that the Workers' Comp Commission takes on farther down the line. On its surface, I don't object to this policy decision, but I think we ought to be very careful about how we manage it. And maybe if you could just address those things, how are they going to do this without hearings? And are they capable of making those decisions even with that information? And finally, did anyone testify from the Workers' Compensation Commission?
I did not. I looked at the testimony and did not see any testimony from the Workers' Comp agency. In terms of how would an administrative law judge determine that it was okay to sign off on an approval? Again, I think the law is very specific. What's being proposed here is they would have that authority to do so if there was no appeal requested, no right to a hearing requested by the employee. So I think that is envisioned in the legislation that's before us. Senator Sampson?
Thank you very much for those answers, and I appreciate it. I hope that if this bill continues out of the committee today, we can continue working on the language to make it, I think, more in recognition of what we are putting on the Workers' Comp Commission and those administrative law judges, because I don't know that they're going to be prepared for this to happen or wanting to take on the responsibility of making these decisions without having knowledge of the facts. And then the consideration is if that's the case and they require hearings in every case, then what is going to happen and will we have the proper staffing? I just think that there is a chain reaction of events that could occur with this type of legislation that we haven't really thoroughly vetted before we're deciding to JF this bill today. That's all. Thank you, Madam Chair.
Thank you. I didn't see which hand went up first, so I will start with, I'll start alphabetically from Z. So I'll start with Representative Yakarino.
Thank you, Madam Chair. I just was reading the bill over, and I think it's well intended, but it is a little confusing. Just for clarification, if I go on workers' comp and I take Xarelto, it's a blood thinner. While my intent obviously is to go back to work with the company, it's not permanent disability where I'm on workers' comp. We're going to go back in X amount of days. Currently, is it common practice where somebody's benefits are changed while they're on workers' comp? It's new to me, to be honest with you. And if so, I didn't know if the company could just, if they still have the insurance, why would if they still have health insurance, how would they lose the benefits for their prescription? Is this common practice? That's what I'm asking. I don't know. And I wish I saw this earlier. I would have called a friend that does a lot of this work, and I just didn't. I just had a tough morning. I was at the doctor's all morning.
There was testimony that it does happen and that it has happened. We didn't get any testimony about how frequently it happens, but the fact that it happens is I think, a concern and something we should address.
And they still have their health benefits, but then they're just changing the types of coverage, the types of prescriptions.
Under current law, I believe they're allowed to an insurer is allowed to discontinue coverage of a prescription drug. And that's what caused this proposal.
Only because they're on workers' comp.
I believe they have that. I think they have that ability to do so. Even if they weren't on workers' comp, I believe insurers can discontinue coverage of a prescription drug. Certainly that's been my experience over the years.
All right, I got to give it some thought before I vote. Thank you.
Thank you.
I think we need a little more information. Public hearing, I don't think gave a lot of information, to be honest with you.
Thank you, Representative Weir.
Thank you, Madam Chair. I listened to your example and I heard the testimony last week or when we had the hearing, and I think it is laudable, and I think it's completely reasonable and sensible to avoid having the employee show up to the CVS window and find out that that the prescription has been discontinued or another drug perhaps has been put in its place. So I certainly can support the concept of giving notice and requiring notice, making sure that all parties involved are as informed as they can be. I'm concerned and maybe not 100%. I don't completely understand the mechanics of if we go to section 2B, for instance, where lines 28 through 31, where the employer or the insurer must identify the employee, the employee's attorney, other representative. Certainly would they'll know, either the employer will know who the insurer is likely, or the insurer will know who the employer is. But what's the mechanism for identifying the employee's attorney or other representative, whoever that may be? Who is responsible for identifying, how does an employer know an attorney of the employee, if so, or what's that process look like for identifying those people and filling in the blanks? Through you, Madam Chair.
And I'm assuming that the process for this would be, in most cases, when you have a workers' comp case, there is an attorney involved and there's a process that's involved, and attorneys are known to the employer and their attorneys during the workers' comp process. And so I'm assuming that that is why that is included there, because you'd want to make sure that the employee's attorney was also on notice, that they have a right to appeal for that decision by the employer or by the employer's insurer.
Okay, thank you, Madam Chair. And as an employer, and I've had employees, we've had people who have been injured, and I've been party to that process. I don't recall ever having an employee with, not that it couldn't happen. My recollection is we notify the insurance company, there's been an injury, the workers' comp insurance company gets involved, and work as a team. I don't recall an instance where an employee had an attorney involved, so I'm just, I guess at that point, is the onus on the employer or the insurer, or is it on the employee to identify that I've retained counsel and here this looks like it's on the onus of responsibility is on the employer or the insurance company to identify that representative or employee's attorney, where I would see that would be more on the onus of the employee to identify like, hey, I've retained counsel and here's who I want you to speak with. This isn't clear to me here.
Thank you for that comment. Any other comments or questions? Representative Ackert.
Thank you, Madam Chair, and I'm going to support this legislation as we move forward, and I'll try to get a little more clarity, and then we'll see how it works on the floor. But at this point, I want to support this legislation. Thank you, Madam Chair.
Thank you, Representative Ackert. Senator Sampson.
Thank you very much, Madam Chairman. I just, after listening to all the dialogue, I find myself wanting to support the legislation before us, but I am concerned that we do address some of the things that I mentioned earlier when I was speaking. In particular, the notion that an administrative law judge needs to know about every one of these items. I think it would be far more sensible to limit their interaction to only the cases where the employee actually asks for a hearing. And I think it might work a lot better. I'm going to vote no here in committee today, but I could get to yes if we revise the kind of process that we're talking about in the language so that it is a little less of an imposition on the Workers' Compensation Commission and a little less of an imposition on employers. So thank you very much.
Oh,
Representative Iaccarino.
yeah, thank you. I just called a buddy of mine. What he said, what happens is if they lose say their workers' comp coverage, it goes to the primary care insurance, and then they still get that benefit is through the company. There's just two different policies, I guess. So maybe it's a little complex, but generally the coverage is going to be there. I don't have anybody from the insurance company here to verify that, but I just double check with an attorney that does this all the time. And he said that if they lose, they get denied, and it does happen, he said, it does happen where they'll get denied, say, X coverage, and then it has to be transferred over to the primary insurance. That's all. I didn't know if you knew that or not. And I don't know how I'm going to vote because I don't want to see anybody lose their coverage, but I think they do get the coverage.
I appreciate that. And I also know that under primary insurers, there's often questions about which medications are covered. I know that from my own family experience, that there are times when, and that's very common, where a prescription drug that has been prescribed by a doctor is not covered by that primary insurer. So I do see that could happen under these circumstances. I appreciate your checking on that, though. Thank you. Representative Weir.
Yes. So before we go to the vote, I just would like to state that I'm going to differ from my colleague, Senator Sampson. I'm going to start today with a yes, with the hope and the intentions that we'll get clarity on these items at some point and have input to make sure we're not unduly burdening the Superior Court judge, the process. We're not cutting people out of line who are already in line. I think I'll be a no if we're going to, I'm sorry, I will be a yes if we're going to work towards clarifying those. And if we can't, then I'll be a no down the line. Thank you, Madam Chair.
Thank you, Representative Weir. Any other questions or comments? Seeing none, I would ask the clerk to call the roll.
A motion has been made and seconded on agenda item 5, House Bill 6550, an act requiring notice of discontinuance of prescription medication under a workers' compensation claim. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Senator Sampson votes no.
Representative Ackert.
Representative Ackert votes yes.
Representative Hall. Representative Hughes.
Rep. Hughes votes yes.
Senator Lesser. Representative Weir,
Representative Weir, yes.
Representative Yakarino.
Representative Yakarino votes yes.
Thank you.
Thank you. The votes will be held open. Moving on to item number 7, House Bill number 6553. Is there a motion?
So moved, Rep. Hughes.
Is there a second?
I will second it.
So it's been moved and seconded. Is there any discussion?
Madam Chair, what bill did you just call out?
6553.
Yeah, we're on 6551, yes?
Oh, I'm sorry. I didn't mean to skip that. I appreciate see, I try and check these off when
I am listening.
we can.
I'll
since we-
withdraw my motion
Well,
then.
since we've had a motion in a second, we can
Oh.
go ahead with this and come back to the item.
Okay,
Thank you.
then I stand by my motion.
Got to be careful not to check things off until we're really done. So there's been a motion on House Bill 6553 and a second. Is there any discussion? Seeing none, then I will ask the clerk to call the roll.
A motion has been made and seconded on agenda item 7, House Bill 6553, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez, Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Acker votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino.
Representative Yakarino votes yes.
Thank you.
Thank you. The votes will be held open. And now we will go back to item number 6, HB number 6551. Is there a motion?
So moved, Rep. Hughes.
It's been moved. Is there a second?
Second, Representative Wilson.
It's been moved and seconded. Is there any discussion? Representative Ackert.
Thank you, Madam Chair. And, I heard quite a bit of conversation, at the, during the public hearing. And it's my understanding, that right now, these, and I couldn't believe the contract length, first and foremost, in these agreements, that, and you can verify this if you would, please, that right now we have a wage that if you're working in state property or state organization, that we have standard rates that we're supposed to pay individuals, say more than a minimum wage, whatever it may be, whatever the negotiated number is, that in contract, these individuals that go into contract or a service provider in some way, they're obligated to pay a wage that is in the contract. Is that correct through you, Madam Chair?
There is an existing and current law, a standard wage provision, and that does require employers who lease property from the state to conduct business that presumably benefits the state, that obligation is there now in current law to pay a standard wage.
Thank you. And that we have employees in certain areas, and I think this is really the I-95 corridor or maybe Merritt Parkway, that we have individuals that have service areas, whether they're janitorial, service maintenance, or wait staff, that aren't getting paid that. Is that correct through you, Madam Chair?
There was a big case recently where they were determined to not be receiving standard wage at a McDonald's on the I-95 corridor, and it was a major case that was in the press a lot.
I guess what I'm trying to make sure is that they're aware of, when they go into these contracts, that they're supposed to pay these wages. Now we'll get to the paid leave part afterwards, but right now I'm just making sure on the wage part, because if I understand, if you have a contract, you write a contract with the state of Connecticut and say that, yes, I'm obligated to pay these wages to the individuals, that they have to fulfill that obligation. And I mentioned to a point that I know in my business, I have to literally put on the wall what you're supposed to get paid and your benefits and everything that you're supposed to be obligated that by law, our labor calendar, our labor posters, right? And I asked them, do they have these posters that say you're supposed to get paid this? And they said, no, we have no, we're not aware of what we're supposed to be paid. We're finding out that, yeah, we're not getting paid that correct amount. And so is it the understanding that these groups that go in, whoever makes the contract, that they're supposed to pay this amount and they're just not fulfilling their contract? Is that true?
That is my understanding. And as to the question of the poster, there is language in this proposed bill that that they be required to post that in the same form that you were speaking of earlier, so that everyone will be made aware of that. But in that case that occurred recently, the DOL determined in the AG's office that they had violated the law, and there was a substantial back pay amount that was owed to the workers. And I think what the intention of this bill is, and I've heard this from the proponents and the advocates, is to make sure that in law, we're being very specific and clear so that it doesn't take months and years for workers to adjudicate a case, that hopefully that would clarify it for the employers that, you know, have maybe not been as clear as what their obligation is, and that posting and the other elements of this in this bill would make it clear, and that we would have fewer cases like this, and workers would be paid according to what is already exists in law.
Thank you, Madam Chair. So, and I support that component of it, that if you're contracted and you're supposed to pay this and you're going to an obligation with the state of Connecticut on a standard wage, then I support that. There's that component of this, and the notification component also. The piece I'm not sure of that is been in the past is the leave portion, the paid leave provided. Is this a new obligation by these by the people that have the contract to now provide certain days of paid leave and subsequent? Obviously, paid leave is going to be at the same wage. I would imagine that's how it works with paid leave. But is that an addition to what was an obligation in the past, through you, Madam Chair?
I believe that the cases that were heard did in fact conform to what we're putting into law here. And so that this would clarify it. So it was wouldn't take so long to litigate. I also know that this specifically addresses where the paid leave is an obligation of an employer by the state or any other government entity, that would not be considered as something that the employer was giving to the employee.
Thank you, Madam Chair. I'm just clarifying that all we're doing is the contract that these companies are fulfilling, that was, and I don't know if that was part of the contract. I'm not privy to their contracts, but that's what I want to make sure. So if we're just equalizing, and that's what I'm trying to find out, are we equalizing what is supposed to happen on these other facilities, like we're doing for people that fall under the standard rate and paid leave, Madam Chair?
That is my understanding.
Thank you.
Any other comments or questions? Seeing none, then I would ask the clerk to call the roll.
A motion has been made and seconded on agenda item 6, House Bill 6551, an act concerning standard wages for certain service workers and paid leave. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson,
Representative Wilson votes yes.
Senator Cabrera, Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Ackert votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino.
Representative Yakarino votes yes.
Thank you.
Votes will be held open and we'll move to item number 8, House Bill number 6552. Is there a motion?
Rep Hughes, so moved.
Second?
Second.
Is there a second? Representative Sanchez seconds. Is there any discussion on the motion?
Go.
Senator Sampson.
Thank you very much, Madam Chairman. Early on when we brought this bill up the very first time, I think as a concept, it was described as going to be technical changes. But now that I see the proposed substitute language today, I see that these are pretty substantive policy changes. Leaving aside that I don't like this program in the least, because I believe it is in direct conflict with private entities that offer the same service. And for the record, we're discussing a bill that has to do with the My CT Savings program that was passed a couple, maybe even 3 years ago at this point, and has never really taken off. And now I guess under the guidance of our new comptroller, former Representative Scanlon, Commissioner Scanlon has been charged with getting this thing up and running and making it work, which is, I suppose, his prerogative. And I wish him luck in as much as I don't like the program at all. I would like to see it succeed as well as it can. But I do have some real significant concerns about the language that is before us. And I guess the first thing what I would ask is, well, even before let me ask say a few things before I ask the question, which is that we don't really know much about how this program is working. I've only had a handful of constituents reach out to me who've had any interaction with it at all. And it seems to me it's very confusing, because I don't think that the typical employee recognizes that the state would ever do something like this. And unless they're following the news closely, they don't even know that it's happening. But I think people are often surprised when they learn that the state is taking money out of their paycheck for the purpose of a retirement account. Many people have their own retirement accounts. That's the whole point of having a private sector that engages in financial products, so that they can sell all types of retirement vehicles for the free citizens of Connecticut. There's no reason to have the state engaged in that activity, and certainly not in a system that requires someone to opt out of it after being placed in, whether they wanted to or not. And I see that the plan, as bad as it was, I think is actually worse in practice if this proposed substitute language passes, because I think what you're doing first and foremost is now you have the implication that there will be penalties placed on employers for failure to comply. And I don't know that this system is such a well-oiled machine at this point that employers even know how to comply, let alone the employees that are affected by it. I had one constituent who says that she's been trying to opt out of this thing for 3 weeks, and her employer keeps assuring her that they're attempting to do so, but so far it hasn't made it through its final process to have her removed from the payroll deduction. And I guess the problem is that there are conflicting federal laws at stake here as well. Anyone that has a retirement account, whether it's a Roth IRA like this or something else, recognizes that there are limitations on the amount of money that you can place into those funds. I don't know what they are off the top of my head, $6,000 or $7,000, I think. And many people have the practice of putting that full amount in. Me personally, I do it every year when I do my taxes because it just makes sense to do it. And they give you up until April 15th to do that. But this is going to confuse that issue for a great many people, and not only confuse it. I guess my larger concern is the impact to people who end up exceeding the IRS limit. They can actually face a penalty from the IRS. And I think if this is just an element of confusion that we don't need to be adding to the citizens of Connecticut when they have access to these types of products without our involvement. Now, there's nothing I can do about repealing that law right now. I'm faced with nothing more than this substitute policy language. The The first real substantive change is in lines 27 through 32, which basically says that covered employees now means someone who's been employed after only 60 days rather than what was in the statute when it was passed, which was 120 days. And the concern there is that, there are a great many employers that have a probationary period when they hire someone, and they don't even offer them any benefits until 90 days goes by or something like that. And I think it's just somewhat dangerous to have a policy that goes into effect too soon. Partly because if you have a particular employee who is going to go through several jobs over a period of time, or even in 1 year, the amount of money that's deducted and accounted for may be difficult to track, both by the MyCT Savings program and the employee themselves. That's just one thing. I noticed that in section 2, there were some changes to the board, but I also recognize that it looks like the board has kind of been limited to an advisory role, so they don't have a real impact in how things are going to be taken care of. And that brings me to what I consider to be the real problem with this bill, which is, I think in section 3, it's lines 159 through 163, which is that you're empowering the comptroller of the state of Connecticut, who I don't know historically has ever been envisioned to have this much power and control over a state program. Line 159 says the comptroller may adopt regulations in accordance with the provisions of Chapter 54 to implement the provisions of these sections. And I think that's highly dangerous. I think that in a program like this, the legislature has an obligation to set the policy, that we should be debating and voting on what the policy is. More and more in the state government, and it's been going on in the federal government for a long, long time, legislative bodies have been transferring their authority to make law to bureaucracies. And this is just another instance of that. We should be making the regulations about how this thing is going to be run and adopted. We should not be saying one person, an elected partisan official, should be in the business of making the regulations to administer this program. Because lines 161 through 163 add that the comptroller may adopt regulations concerning program enforcement activities, including but not limited to financial penalties for the administration of the program. So we're going to give the comptroller the power to penalize employers for failing to follow a program which is in its infancy and it does not have a good track record so far. I think these are dangerous things. I think that removing policy making from the role of the legislative body that's responsible to the constituents is dangerous every time it happens. And this is just a very obvious and I think egregious example of granting too much power to an executive branch agency, which really ought to be left to the legislature to handle. And I noticed, by the way, that this language giving this authority to the comptroller was not in this bill during the public hearing. So no one had had the ability to even comment on that because it wasn't a reality. It only showed up at 6 p.m. last night in my inbox in the substitute language. And I don't think that's fair to the public to leave that out of the public dialogue for this bill. And I do think it's quite egregious. And there's many people in this state that would agree with me that we should not be not only doing this program, but giving the comptroller this power to levy financial penalties. I'm going to be a very hard no on this bill today, Madam Chairman. Partly because I don't like this. I would call on my good friend and former representative I spent a lot of time with on the insurance committee, to reconsider the rollout of this program and how aggressive they want to be about it. The fact that it exists is one thing, but to make it really a heavy-handed program that is going to require employers to start enrolling people right after they're hired and not being able to process their ability to opt out in a timely manner, et cetera. To me, it's dangerous, along with my earlier comments, which is that we're going to put certain employees in danger of paying fines for exceeding the IRS limits. I wish these things were more well thought through before they come to us and are passed out of the committee. Thank you, Madam Chairman.
Thank you. And I will recognize Representative Weir.
Thank you, Madam Chair. I heard a couple of Senator Sampson and some of his concerns. And again, as an employer, having employed many people over the years, I'm concerned with certainly the probationary period. Certainly potentially putting an employee at risk if they're already maxing out their his or her contributions through the employer offered plan. I know we always have offered, maybe not always, but for many, many years, our small business offered employees an opportunity to, on their very own, contribute to their retirement with us providing a match. And I'm concerned that if somehow that an employee gets entered into this program, doesn't opt out, doesn't realize they're entered into it, and then is also participating in employer offered plan, that they may exceed those maximum contribution thresholds and could be, I think this was touched on, but I just want to clarify that I can see mechanically how this could happen, having run a small business, that they could be in jeopardy with the state tax authority, Department of Revenue Services, or the IRS, with the best of intentions here. But because this program has little fanfare, is not well known, I quite honestly was not even aware of it as an employer until I became part of this legislative body. Didn't even realize this exists. And perhaps that's ignorance on my part, or perhaps it's because as an employer, we were offering a program proactively, looking out for our employees, looking out for their we were looking out for them, and consequently the employees certainly are looking out for themselves and being proactive. So I do have concerns with with the best of intentions of this program, putting an employee at risk unknowingly, where they're in violation of the tax law. We talked about having a probationary period. That certainly is a concern. That's a major change in my opinion. Just because you have employees who come, they may or may not work out. It may not be a fit. The employee may leave short term, and so having that probationary period set by the employer, or mutually agreed upon, I should say, between the employee and the employer, because that any agreement entered into between a private employer and a private employee can be negotiated. No reason that the two parties can't negotiate benefits and salary and all sorts of other terms of the employment. So I am concerned with taking that from 120 to 60. I think that's much too short of a period of time, and to me that constitutes a major change. That's not a minor change. That would affect hundreds, if not thousands, of businesses potentially in Connecticut. So those are my comments, and because of those, I think this is an overreach. There's an opportunity to educate employees, certainly on employment plans. I know we were always looking to do the best for our employees and see them succeed. And so making them aware that it's a good idea to be putting money aside for retirement and putting it aside for the future is something that it's important for employees to have that knowledge, but I don't think that's the state's role. And I think this conflicts with how a private business is going to operate, just going to muddy the water. So I can't support this as it's written today. Thank you, Madam Chair.
Thank you, Representative Weir. And I just want to make sure that there's understanding of the program. If an employer offers a 401k, as you spoke to just now, you are not required then to enroll with the state comptroller's office in this program at all. So you just have to verify when asked, because you get a letter from the comptroller's office. You have to verify that you have a program. So you would not be required to offer this to employees if you already have a program in effect. So there wouldn't be a duplication there. I think that's the first thing. And then secondly, in terms of the question about probation, and particularly raised about employees maybe going to multiple employers during a year, when this program is set up, none of the monies come out of the employer. So there is no employer contribution into this plan at all. So it's not a question of the employer giving a benefit to the employee. It would, however, provide for an employee who had previously been enrolled in the program to continue after a very short 60-day waiting period to continue making contributions on their own. These are individualized accounts. They're not tied to the employer. They're only, the employer's requirement is only to set it up and have employees have that option of enrolling. They're not automatically enrolled, and it's not an opt-out. They have to opt in. I hope that clarifies.
A little bit, Madam Chair. I just think it's cumbersome, and it's one more thing for the employee to navigate. Again, if for some reason I think of always the worst case scenario, because Murphy's Law and running a small business in any place, never mind Connecticut, it's if somehow that communication between the comptroller's office and the employer goes, it doesn't reach the employer doesn't know. Let's just say they don't offer a plan, or they do offer a plan and they don't have the opportunity to communicate that back to the controller's office. I just think there's this is probably something that, the opt-in is great, but it sounds more to me like a burden. So that's my statement on that. Thank you.
Thank you. And, I strongly support this bill because I think that we all agree, I think, on the point of having employees save money for their retirement. And so I think it's a really good bill and something that I'd like to see move forward. If there are issues in here that we need to address down the road, I'm sure there'll be plenty of opportunity before it gets to the floor, but I do think it's a really good bill. And I appreciate the comptroller taking responsibility so quickly, having just been sworn into office, to make sure that we have a strong program that we can move forward. And I think that will be good for workers in Connecticut for now and for the future. So, but I appreciate all the comments. Senator Sampson.
Thank you, Madam Chairman. I just wanted to clarify for the record that this program is an opt-out program. It is not an opt-in program. Employers are required to start taking the money out based on that 60-day time frame. And it is up to the employee to advise the employer that they wish to opt out of the program. That's one of the main negatives. I'll also add that, you're putting a burden on the employer either way here, because you're effectively asking them to do work on behalf of the state of Connecticut without compensation. I mean, employers have a lot of other things to do to run their own businesses without taking care of a competing retirement program that the state offers. So it's another mandate on businesses. It's another reason why, if people are given a choice whether to open their new company in Connecticut or another state, they may choose that other state. We've got to stop putting more and more burdens on those folks. Thank you.
Representative Acker.
Thank you, Madam Chair. And I still have some concerns on the changes that we made. First and foremost, the time frame. I brought this up in our discussions earlier, why we went from 120 down to 60. But my question, essentially, I want to make sure that when I think about how we're handling this, so qualified employer is actually pretty much any employer other than, some of the public employees, correct? So I see what it says here, but I thought in a way, if a qualified employer has an existing plan that they wouldn't even need to be part of this. I mean, I know that my company has a retirement plan, and so there should be no obligation. Once I fill the form in, I believe that's my obligation is done. Is that not correct through you, Madam Chair?
That is my understanding. My understanding is that this, and I heard what Senator Sampson said, but it is my understanding that the employer has to provide the comptroller's office with the names of the employees, that that the comptroller's office then creates a login number for the employee. But if they never go in and log in and authorize a deduction, that there is no deduction. That's my understanding from the comptroller's office. And hopefully, as we move through this process, there'll be more clarification if necessary.
Yes, and there might be, Madam Chair. I'm just thinking that if company A has a retirement plan, that the form is submitted in saying company A has a retirement plan, here's the case, and that's it, done. There's no list of employees, there's no anything. It's just completed. Doesn't read that way, I believe. And I know that's current law, but I had thought that the obligation was kind of over when you sent in the form saying, no, my company A has a plan and we're done. But I don't think current
Represent-
law represents that.
I believe that was the testimony of the comptroller, though. When we had the public hearing, I know that question was asked of him, and that was his testimony.
Thank you. And I'll look forward to digesting that a little bit more. The other part that I had paused with was, why are we taking shall out on 164, line 164, making it a may?
My reading of that is that it allows the comptroller's office to take on those responsibilities themselves rather than providing those services through the Department of Labor or other state agencies. So in other words, it reads now, the comptroller shall enter into a memorandum of agreements to do the following. And there's a number of things itemized there. And this allows the comptroller's office to do those things, but it doesn't require, it allows them to basically contract out those responsibilities to other agencies of the government, but it doesn't require them to.
Thank you. I read it like, okay, so I'm looking at it from your point of view and look at it that way. And so I just thought it was a point where there's a little bit of checks and balances there for the comptroller's office and working with the Department of Labor or other agencies. But I can see it, your description of that. And thank you. And obviously I have some strong pause with section 159 and 163. That is the S language that was implemented. To be honest, we knew that was coming. I mean, it was brought out by the comptroller that he wanted to get more strength in this legislation. And I think that I have concerns with that. And when the dialogue that I heard from Senator Weir, opportunity, that a lot of businesses aren't aware. There's some very small businesses really don't know about their obligations with this program. A lot of times we do a lot of good work up here, and the word just doesn't get out. And I know that everybody's got busy lives, but the word doesn't get out. And the next thing you know, we're collecting revenue from a fine or a penalty or something along that line. And I would say, listen, let's make a proactive approach to implementing this plan. I have a retirement plan for a reason, because I believe that my good workers deserve an opportunity to invest in their own, in their own plan. There was one section in current law also that said that an individual opts out by choosing zero. When you put your form in, how you opt out is you say, I'm contributing 0%. But your name must still stay in the system. Would you say that is correct through you, Madam Chair?
My understanding is that each employee is given a login opportunity, and they have to log in to initiate this. Also, just in terms of when the comptroller testified, I believe he testified that to your point about making sure small employers know about this, that they get a letter from the comptroller's office advising them of this. So I do believe there's some proactive piece of it for the comptroller's office.
Yeah, I believe he said about 1,000 have responded. Is that
Correct.
what the number that you heard?
It sounds familiar, but I can't.
Yeah, I think it was about 1,000, and that's one of the concerns, I believe, that in some of his so we have a lot of businesses in the state of Connecticut, so thousands of a minuscule amount. So but I'm a no on this, and we'll look at if this legislation changes a little bit more palatable, that I can support it. So thank you, Madam Chair.
Thank you. Any other hands, questions, concerns? Seeing none, then I will ask the clerk to take the roll.
A motion has been made and seconded for a roll call vote on agenda item 8, House Bill 6552, an act concerning the Connecticut Retirement Security Program. The motion is to JFS this to the floor with LCO number 4335. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
I'm sorry, I didn't see you on screen there.
Representative Wilson votes yes.
Thank you. Senator Cabrera, Senator Sampson,
Senator Sampson votes no.
Representative Ackert,
Representative Acker votes no.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Weir,
Representative Weir, no.
Representative Yakarino.
Representative Yakarino votes no.
Thank you.
I have to hop off for Zoom, but I'll be back on for ZECD.
That's fine. We will be holding votes open. So,
I was tied up with.
so we will hold the vote open. Moving on to item number 9, House Bill 6594.
Rep. Hughes so moved.
There's a motion and it's been seconded. Is there any discussion? Senator Sampson.
Thank you, Madam Chairman. This is an act concerning non-compete agreements. I really do wish we worked harder on making the titles a little more explicit, since this has to do with effectively eviscerating non-compete agreements. I don't know that that would be a title that LCO might choose, an act eviscerating non-compete agreements, but effectively that's what it is. And you know, I heard the testimony, and I've heard the comments from some of my colleagues about the desire to protect some low wage employees from unscrupulous business practices. And I'm certainly sympathetic to that. And I can completely understand that somebody who's going to work at a fast food restaurant or something shouldn't be expected to sign some giant, 100-page document that has, a lot of contractual language and restrictions on their further, employment choices. I'm sympathetic to that in one way, but in another way, I also do believe that, as I mentioned earlier in this meeting and during the public hearing, that private contract between their employer and employee, again, is between them. And every aspect of it, in my mind, is their decision and not ours. So the thing about the bill is that the bill doesn't go out of its way to protect low income workers. In fact, it imposes these restrictions on people that are currently making as much as $90,000 per year for employees, and the sky's the limit for independent contractors. If it was limited to something in the sub 50,000, sub 40,000 range, then you might be making a compelling argument that you're trying to propose a solution. Which I don't know that there's a problem. I've never had anyone approach me and say that they work in a fast food restaurant and they have a non-compete agreement, but I take the folks at their word that that's happening. At the end of the day, though, they should have the choice to engage in whatever private contract that they want to. The bill that's before us really does, as I said, eviscerate the notion of non-compete agreements. And what I think is missing from this conversation is the value of these agreements in the real world. They do perform a service, and that service is not always to the benefit of the employer. I mean, that's the mentality, I think, of the majority, is that there's this constant desire, protect the employee from that unscrupulous employer, that mean old corporation, et cetera, et cetera. And that's just not what's happening here. There are people on the employee side of this equation that benefit from these agreements. And if these agreements go away, their opportunity to benefit goes away with it. And not only does an opportunity to benefit go away, but the whole entire opportunity for that job to exist may go away. There are industries that can only survive if the employers are allowed to protect their assets in a certain contractual arrangement with the people that they employ. And that's it. That's the matter of fact. People in the insurance industry, they hire employees who have direct knowledge and communication with their client base. If the employer is the one investing all of the risk and all in the money of developing that client base, they ought to be able to protect that asset and not allow an employee to walk off with their client list and their book of business. That just makes common sense. And what you will be doing if you eliminate the ability for employers to be able to protect their asset by contractual agreement is a situation where those businesses will no longer be able to succeed. They'll no longer be able to enter into contractual agreements with people to grow their business, because there'll be too much fear involved with the potential downside, because this body, the state of Connecticut, once again, has decided that they know better than the people on the street. Our job is not to protect people from themselves. That's not our job. I can't say it enough. Our job is to protect the rights of our constituents so that they can go and pursue their own endeavors in life. That's what our job is. And all effort that is put into lawmaking here ought to be focused on that goal, which is to protect the opportunity of people to go ahead and find new ways to create their own success. That is the American model. And instead, what is happening primarily in this committee, maybe more than a lot of others, is stifling opportunity by suggesting that employees cannot defend themselves and the state must intervene and set up rules that prevent a transaction from occurring. Even the minimum wage is an example of that. And I don't want to go too far on a tangent and be scolded by the chairman, but I'll just say that when you set a minimum wage, you're effectively telling parties that might want to engage in a business arrangement for less than minimum wage that they can't do that, even if both of them are completely willing to do so. To me, that is a negative aspect of having a minimum wage. And that's the same situation here. You know, I mentioned during the public hearing that I was an insurance agent in my late 20s, early 30s. And I was given many opportunities to go and become successful by people that owned a company. And I signed a non-compete, and I did it with my eyes open. I knew exactly what I was doing, and I knew I was being afforded that opportunity because I was willing to sign that agreement. And I profited from it. I had a great paying job and I had a great opportunity. And as time went on, I worked on the negotiation I had with my employer, and we ended up revising contracts, and I got part ownership in the company and the book of business. But that owner needed to be able to develop that relationship with me as I needed to develop it with him. And what we're doing here is just a carte blanche, using a bomb for something that doesn't even require a knife to tweak around the edges. It's very, very dangerous. And the limitations that are in here are also very concerning. Let me just talk about the language in the bill really quick. Section 2 runs through a list of the only ways that a non-compete agreement could remain enforceable in the state. And this list is just like, it's unreal. For one thing, the first one is that it cannot be enforceable for a period of more than 1 year. Well, I'll tell you, there are many, many types of activities that are still completely viable after a year. Certainly an insurance company's book of business would still be very viable to pursue if you left a company 1 year later and decided to wait out the clock and go ahead and try and take the customers that don't belong to you, that belong to your employer. And then these following statements are just incredibly vague. I understand what's happening in this bill is we are shifting the burden of proof onto the employer to defend themselves in the validity of a non-compete agreement by setting up these hurdles. Line 72 says that employer would have to prove that agreement is a legitimate business interest. Ultimately, if there's a dispute in court. I believe that anything that they say is a legitimate business interest ought to be a legitimate business interest. And if it's not a legitimate business interest, then why is the employee agreeing to participate in that agreement? 78, line 78, the covenant is no more restrictive than necessary. Well, who determines that? Is the court or the state or the labor committee today going to decide what is actually more restrictive than necessary? We're not there. We're not working in that industry. We're not working in that business. We don't have direct knowledge of what that is. It's awful bold for us to be passing laws, setting up rules for things we know nothing about. Written copy is provided. I suppose that makes perfect sense. A statement of the workers' rights. Well, I mean, that's another activity that seems to go on in this committee too. We just heard in the last bill that, again, we're making employers do the job of the state. The state's mandating them that you are now the purveyor and deliverer of retirement benefits to your employees, and you're also bookkeeper for the state of Connecticut. Are those people being compensated for that? No. And in this case, the employer is going to be required to be able to distribute information that the state requires, and they will not be compensated for that either. On and on and on. The employment or contract relationship was not terminated by the worker for good cause. I mean, who ultimately will decide that? I have a question, Madam Chairman. Lines 101 through 104. Maybe you can tell me what this means. This is one of those conditions that must be met for a covenant to not compete to be valid. It says, if the covenant not to compete is added to an existing employment or independent contractor relationship, the covenant not to compete is supported by sufficient consideration and is not solely the continuation of such employment or contractor relationship. In other words, is it saying that if you want to change the business relationship, you have to pay the employee? Is that correct? And it says sufficient. What determines sufficient?
I believe this speaks to the testimony we heard where an employee entered into employment, and then after having been employed, they were then asked to sign a non-compete. So they, at that point, had already been employed. So this would invalidate that.
Well, thank you, Madam Chairman. What I'm asking is this is a requirement to maintain a valid non-compete agreement. For me, it says that you couldn't just say that the terms of our business arrangement are changing. You would actually have to say, I need you to sign this agreement, and you'd have to provide what it says, sufficient consideration. Is that accurate?
That is accurate.
Well, thank you, Madam Chairman. I would point out that, in an employer-employee relationship, the terms change regularly. Think of almost any job. If the market changes in a particular industry, maybe there's a pandemic, and businesses are shut down, who knows? Things are changing, and employers need to go to their employees and tell them, say, look, business is great. I'm giving you a raise. Or, you know what? We've been losing clientele to our new competitor across the street for some time, and I'm going to have to reduce the number of employees we have, or we're going to have to change the number of hours. And that has a real world fact and reality. But I know I mentioned the employer, but employees do this also. Employees say, well, you know what? I'm going to start going to the gym on Wednesdays mornings. So I'm going to tell my employer I can't work on Wednesday mornings anymore. And they're going to have to decide whether they want to keep me or not. During the public hearing, that was described as a take it or leave it kind of attitude when the employer does it to an employee. But I just want to point out, not in defense of employers, but in defense of both parties, that both parties have the right to be able to communicate to the other side that they want to alter an agreement. And that is, unless they have a contract stipulating otherwise, their prerogative to do so. And either side is going to have to decide whether they will accommodate those changes. That's the beauty of living in a free society that we're missing here every second with every one of these bills, that we are eliminating the freedom of people to make their own choices. It's the reason why I wanted to be on this committee, because I need to be able to point this out. People need to be able to be free to choose their employment arrangement, to choose their employee arrangement, and their compensation and benefits on their own. And yes, we have an obligation as a state to prosecute bad actors, but that's not what this is. There's no bad actors involved here. This is a bill that would prohibit a perfectly reasonable and profitable practice for both employers and employees that has a legitimate need to exist in a business arrangement, and for no purpose, because in an alleged protection about that for low income employees that I don't see a problem for. The limits that are listed here I think it is in lines 113, 117. It says this would apply to employees up to 3 times the minimum wage. I did the math, 14 times 40 times 52, that's $87,000 a year. That's still a pretty fair and sizable wage, and certainly more than an entry level salesperson might make or an entry level insurance agent might make. So I think that by passing this law, you may just eliminate those jobs. You may say, I'm sorry, there's no more entry level insurance agents, people that are starting a career that might ultimately pay them 6 figures and giving them a tremendous quality of life and retirement. Their job is going to disappear because we're effectively making it impossible for their employer to start them off in a way that makes sense. I think that's highly dangerous. The limits for independent contractors make absolutely no sense to me. By virtue of being an independent contractor, you're not paid by the hour. So to point out that there should be a limitation, which I think is 5 times, yes, it says 5 times the minimum fair wage is the limitation for which this can occur. And I'm thankful that this is a sizable number. Oh, wait a second. No, I'm not thankful, because it's actually worse this way. This makes the number to allow a non-compete agreement so high that it's going to preclude just about any independent contractor arrangement. And that just doesn't make any sense whatsoever. Most people that work in some industries, insurance industry is for one thing, many of them are independent contractors. Because they're not paid on an hourly basis, I don't know how you can give this 5 times minimum wage figure. Also, independent contractors may have multiple people they contract with. You know, they might only contract with some company or employer for a certain, short period of time. I don't want to get into it today, but be prepared. If this bill comes to the floor, I'm going to want to flesh out exactly what this information means, because it doesn't make any sense. I don't think you can set a limit on independent contractors because there is no hourly wage involved. So I don't know what you're multiplying. I don't know if you're working that out or prorating it over the course of a year or what. And I just don't think that that's a workable thing. Section 3 just applies all the same rules to exclusivity agreements, which are more or less the same thing. I want to just also, Section 4 is the one that shifts the burden of proof to the employer. I mean, again, why are we choosing one side or the other in any one of these situations? Shouldn't the facts speak for themselves? Shouldn't the fact that someone entered into a agreement in writing? And again, look, I know the world's not perfect. Every time I have to click the terms of use on something that comes up on my phone, I get mad because I'm like, I got no choice. I'm signing a contract that I don't want to sign because I want an app on my phone or something. It's ridiculous, and we ought to work on that. But employment agreements are not typically like that. Somebody who works for a sales department of some corporation is not just tossed a stack of papers and here, sign this. They understand, and hopefully we're raising intelligent enough people to be able to negotiate the terms of that agreement so they know how they're being compensated and what the agreement is. And people do have the opportunity to set those rules themselves. And if we live in a free society, competition solves that problem as well by allowing someone else down the street to open up a competing business who's actually treating people fairly if someone else is not. 166 through 169 is also, I said egregious at the start of this, and I mean, this is egregious. It says the attorney general may bring a civil action in superior court on behalf of any worker aggrieved. So unlike in every other contractual business dispute where the aggrieved party would have to hire a lawyer and go to court to fight for their compensation, we're effectively saying that the attorney general of the state of Connecticut now works for employees against employers in the case of non-compete agreements, and they're going to get free representation. I got to say, Madam Chairman, that is like madness. Does the attorney general even know that we're going to give him this power? Does he even want this power? I wonder. Yeah, there's so much more to say here, but I will reserve all that. If this bill ever makes it to the floor of the Senate. And I certainly hope it does not. And I certainly hope it does not in its current form, because this is maybe one of the worst ones on the agenda. This is a job killer, ladies and gentlemen. This will prevent new jobs from being created. It will affect many people that are currently working now when employers find out that they cannot protect their assets legitimately, and offer opportunities to, rising stars in their companies. It's a big mistake. We should stay out of private contracts. Thank you, Madam Chairman.
Thank you, Senator Sampson. Representative Acker.
Thank you, Madam Chair. And the good senator said he could go on, and I'm like, I'm not sure what section he missed. He did a good job of, discussing this piece of legislation. And I also hold pause. Listen, I have some concerns on non-compete clauses in different areas. I've had a constituent that had an issue with a non-compete clause. I think that there's some sections of these that I agree with, and there's some sections that I hold pause to. So at this time, I'm going to be a no, and I'm going to talk to some of the individuals that brought some of these issues forward and talk to us at a public hearing, vet that out, and see if we can't do something with this piece of legislation. But at this time, I'm a no on the legislation. Thank you, Madam Chair.
Thank you, Representative Ackert. Representative Weir.
Thank you, Madam Chair. I have a question and then a couple of statements. In section 1, item number 6, can you confirm, it's my understanding an exempt employee is, and I'm going to be general here, not an attorney, but that it's someone who has perhaps decision-making, managerial type responsibilities, maybe over they're able to determine their own hours, perhaps they're working autonomously, and they're not entitled to overtime. Is that, when we talk about an exempt employee, is that the spirit of that definition? Or is there more to it that I'm missing? My first question, Madam Chair.
I'm very familiar with the federal law on this, but I want to check with OLR for a moment. Under the Fair Labor Standards Act or federal law, this law, I'm told, is similar in the state of Connecticut or identical. And there are lots of conditions that determine who is an exempt employee, who is not. Some of the conditions that you laid out might contribute to that determination, but essentially it's more about decision making than it is about whether you're. I mean, if you want to go back and remind me of the specifics you mentioned, I think it's not one factor, it's multiple factors.
Okay, I think we've captured the spirit of it, but it's almost like an hourly versus salary type situation. And an exempt employee would be, generally speaking, salaried, perhaps not entitled to overtime unless there's a certain carve out or an agreement, and they're autonomous. They're making decisions, perhaps in a managerial status, being versus punching a clock and being told when and where to report with no autonomy. That's my understanding of an exempt employee. Okay, that's my first question. And I guess for the benefit of the rest of the committee, through you, Madam Chair, is I've been a small business owner for much of my life. I'm currently an employee of a company, and as an employer, we we have certain intellectual property. We've got certain customer. There are certain things that are germane to our business that we operated differently than others, that we don't necessarily want to give that competitive advantage to a competitor. And in my current state as an employee, I had to sign, and I didn't have to. I was presented with a non-compete agreement, and I gladly signed it after negotiating the terms of that between my employer and me, and this is within the past year. So I just want to point out that there's an opportunity. It's not a take it or leave it situation. Senator Sampson pointed out that it does work both ways, and it does. I've seen it from both perspectives. I see no reason why the state is interjecting here. This legislature is interjecting, and there may be some of the other members on this committee who are subject to a non-compete or who have been presented with one, and they may consider how they handled it. Was there option for negotiation? I can tell you in my situation there was, and it was worked out fairly. And I would say that I'm comfortable with the terms of that agreement, as is the employer. Otherwise, it doesn't work when you don't have two parties who are ready, willing, and able to come to an agreement. So that's that. I would also note that there's case law for what is considered reasonable. We've put forth as an employer, I was, had a part in designing our non-compete agreement. It was not the same for every employee. Every position may be a little bit different. So it's catered to the employee, and that can be sought out through legal remedy, certainly advice through an attorney as to what's reasonable and what's not. I will also point out that we're in an at-will state, so the employees have just as much freedom over their employment as does the employer. And there's a lot of discretion in these non-compete agreements. So I just want to point out that I think we're overstepping here. Senator Sampson called it dangerous. I do think it is a dangerous precedent to, we already have lack the competitive environment economically. Employers, we see it, and I want to ensure as part of this legislature that anything we're doing is, we're contributing to an economically competitive environment. And I think this is going to harm that. Senator Sampson referred to, I think he covered it on the 85,000 for employees, which is 3 times the minimum wage. And we have, you have an entry-level employee who may be, the employer is taking an interest in that employee, the employee is showing promise, showing initiative, showing that they have a future in that company. But they're not going to start out at the top floor. They're going to start out as perhaps an entry level, and they're going to work their way up. But in exchange for that, the employer is there's going to be a two-way trust. The employer is going to trust that employee with company secrets, confidential information. And to that extent, some of that confidential information needs to be protected. And so I'm concerned that we may box out some of these younger, newer, maybe more entry-level employees who are on their path, who potentially have a path to becoming a top-level employee, a top earner that far exceeds that 85,000, hopefully, or as an independent contractor, 145,000, and that we may be blocking them from achieving that, realizing that opportunity to growth. So for that, I'm a no here, but I'm open to conversation. Looking forward to debating this further. Thank you, Madam Chair.
Thank you, Representative Weir. And I don't see any other hands. So at this time, I'll ask the clerk to take the roll.
A request for a roll call vote has been made and seconded on agenda item 9, House Bill 6594, an act concerning non-compete agreements. The motion is to JFS this bill to the floor. The substitute language is LCO 4374. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Representative Wilson.
Representative Wilson votes yes.
Senator Cabrera. Senator Sampson.
Sampson is a no.
Representative Ackert.
Representative Atkinson, no.
Representative Hall. Representative Hughes.
Representative Hughes is a yes.
Senator Lesser. Representative Weir.
Representative Weir, no.
Representative Yacarino. Thank you, Madam Chair.
Thank you. We'll be holding votes open. Next on the agenda. Get to the agenda. Items number 10 through 15. I'm sorry, items number 10 through 15. Hold on one second. Items number 10 through 15. My understanding is that we will have a motion to take these as a group.
Yes, Madam Chair, I believe that items 10 through 15 can be taken as a group on a consent calendar and a voice vote.
Thank you, Representative
That's a
Packard.
motion.
Is there a second?
Well, go ahead.
It's been moved and seconded that we vote on items 10 through 15 as a group, and that we do so with a voice vote. Are there any questions or comments? Senator Sampson.
Thank you very much, Madam Chairman. I just want to state the usual caveat normally that we say when we raise concepts. Same thing is going on here. These items are being voted to be drafted into bill language And the final item is to be changed to a different committee. So we're not voting on the substance of these bills at this point. There are some of them I can see myself having issues with, particularly item number 13 that I had a very nice dialogue with Senator Looney on at the public hearing. I don't think I can find my way to supporting that one, but I am okay with having these bills drafted into bill language for a later debate. So as long as it's understood that an affirmative vote is not on the actual policy contained within just the notion that we can draft these bills. Thank you, Madam Chairman.
Thank you. Any more comments or questions? Seeing no hands, I will then ask those that are on Zoom to prepare yourself to vote. That means you should unmute. And so all those in favor, please say aye.
Aye.
Any opposed? Any abstentions? Thank you. The motion passes. So with that, I do see that there's an announcement at the end of the agenda that I will read out, that there will be a public hearing of the Labor and Public Employees Committee on February 23rd at 10 a.m. in room 2B and via Zoom, and that there will be a committee meeting on February 28th at 10 a.m. in room 2B and via Zoom. And thank you all for being here today. And with that, I would entertain a motion to recess. We will be,
Recess.
we don't need a motion to do that. We'll just be recessing and it is now 12:30. Let's hold votes open either on Zoom or in room 3800 until 3 p.m. Thank you, everyone, and we'll see you at the public hearing or the next meeting. Thank you. It will just take a moment for me to be made a co-host to allow in members of the committee to vote. I'm unmuted, but I'm not the host yet. Still 1 minute.
We're still working on it. Okay.
Yeah, that would probably.
Okay.
All the money is spent on infrastructure, putting foundations and.
Representative Yakarino.
Sorry, go ahead. I'm here.
The clerk is ready to take your vote.
I'm here. I'm just, I'm on a DCD call in the background.
We have bill number,
Could I call you back in 10 minutes or no?
certainly that would work.
We held open the votes until 3 p.m.
Okay, thank you. I'm all set though. I'll call you back.
You call back. You have.
I'm actually just gonna leave this on hold. All right, thank you. Subject to certain restrictions and requirements.
Hello. Oh, can we get the TV up? Sorry about that. I think we're okay. Nope. Hello. Okay, I think we're good again. No feedback with this time. Okay. Hello, Senator Lesser. Hi, how are you? Senator Lesser, I'm not sure if you're still there. It appears that I am reconnected to Zoom and the technical issues have been worked out.
Hi,
Hello, Representative Garino.
how are you?
Good, yourself?
I didn't vote on a couple of bills.
Yep, I'll go through the list right now. So I have
Yeah.
agenda item 1, that was SB 910 JF to the floor.
No, it's a no.
I'm expecting we would hear back from the DCD in the very near future.
Okay. Then there was a number 2.
I have you on number 2.
I voted.
I have you voting no on number 2.
How about 3?
I have you on, let me see, I have you on
Oh,
2.
so what did I miss? Number 9?
One moment here. I have you did not vote on number 9, so that would be House Bill 6594 JFS to the floor.
No.
Okay.
I'm all set. And the voice vote. Thank you. Have a good day. Bye-bye.
Hello. Hello, Senator Lesser. I have the votes right here, ready to go. So agenda item 1, vote JFing SB 910 to the floor.
Sorry, say that again.
First one is agenda item 1, JF SB 910 to the floor.
In support.
Okay. Second one, agenda item 2, JF SB 911 to the floor.
In support.
Item 3, SB 912, JF to the floor.
Support.
Item number 4, SB 938, JF to the floor.
Support.
Item number 5, House Bill 6550, JF to the floor.
Support.
Item number 7, because that was next, House Bill, write that down, House Bill 6553, JF to the floor.
Support.
Okay, votes went a bit backwards here in the meeting. Then it was 6, 6551, JF to the floor. Senator Lesser?
I support it.
Okay, apologies, I didn't hear. Agenda item 8, that would be 6552, JFS to the floor.
In the affirmative.
Agenda item 9, House Bill 6594, JFS to the floor.
Affirmative.
And the last votes were voice votes.
Great. Thank you.
Hello, Representative Sanchez.
Hello, Cameron.
So the only one I have that you missed was agenda item 7. That would be, one moment here. House Bill 6553, JF to the floor.
Representative Sanchez votes yes.
Thank you very much.
Thank you.
Hi, Mr. Clerk.
Hello, Senator. So the bills that I have that I don't have your vote on are agenda item 2, SB 911, being JF to the floor.
Yes, Senator Cabrera votes yes.
Agenda item 3, SB 912, JF to the floor.
Senator Cabrera votes yes.
Agenda item 4, SB 938, JF to the floor.
Senator Cabrera votes yes.
Okay, just give me one moment. I'm going to let Rep. Hall in so he can vote right after you. Agenda item 5, SB or HB 6550, JF to the floor.
Senator Cabrera votes yes.
Hello, Representative Hall. Senator Cabrera is just finishing up his votes and we'll restart with you in a moment. Is that all right?
That's fine.
Thank you. Item 1, okay, I already have you for that one. Agenda item 7, that would be House Bill 6553, JF to the floor.
Senator Cabrera votes yes.
Agenda item 6, HB 6551, JF to the floor.
Senator Cabrera votes yes.
Agenda item 8, House Bill 6552, JFS to the floor.
Senator Cabrera votes yes.
Okay. And last one, agenda item 9, House Bill 6594, JFS to the floor.
Senator Cabrera votes yes.
Thank you very much, Senator.
Thank you, Mr. Clerk.
Just give me a moment. I'll just get these back in order to make this easier.
No problem.
Here we go. I have you on 1 here. 2, I've got your vote accounted for. Here we go. So agenda item 3, SB 912, JF to the floor.
Yes.
Agenda item 4, SB 938, JF to the floor.
Yes.
Agenda item 5, House Bill 6550, JF to the floor.
Yes.
Agenda item 7, House Bill 6553, JF to the floor.
Yes.
Agenda item 6, House Bill 6551, JF to the floor.
Yes.
Agenda item 8, House Bill 6552, JF to the floor.
Yes.
And last one, agenda item 9, House Bill 6594, JFS to the floor.
Yes.
Okay. Thank you very much, Representative.
No problem. Take care.
You too.